Members, we move now to consideration of the Immigration Amendment Bill. When we were last considering this bill, we were debating Part 1. Sue Moroney had the call and has 2 minutes and 58 seconds remaining if she wishes. The Honourable Michael Woodhouse.
Thank you, Mr. Chair. This is my first call on the committee stage of this bill, which I'm responsible for passaging through, and I had hoped to answer the probing technical questions that had been raised by members of the committee when this committee stage started, but sadly, Mr. Chairman, the debate so far hasn't been replete with such erudite technical questions. Nevertheless, there are some elements of the bill that I do want to touch on, including its background. But before I do, I just want to acknowledge the many hundreds, perhaps more than 1,000 emails that I have received expressing concern about this bill, and in particular that it may be in breach of our obligations under UN conventions on refugees, and specifically the 1951 Convention. I have done my best to reply to all of those emails. I may have missed a few, and certainly have been appreciative of the further feedback that I have been getting in correspondence about this. The point I do want to reassure members in the House and of the public is that the government takes its obligations in respect of its conventions very, very seriously, and is satisfied, as is the Attorney-General, that this bill, when passed, would not constitute a breach of those conventions. I must say it doesn't help when organisations like Amnesty International make comments about unlimited detention under this bill, which are simply not correct. It is not possible for somebody to be detained indefinitely, as was stated in a recent report that Amnesty International released. I just want to remind the committee of the background to this. In 2011, an operation was undertaken an exercise was undertaken to assess New Zealand's preparedness for an irregular maritime arrival, a mass arrival by boat. And this was a very helpful exercise known as Exercise Barrier, which identified a number of issues requiring improvement, and this bill is one part of those. It firstly seeks to deter a mass arrival. And the simple fact is this: we do not want these people to come. We don't want them to come for the simple, singular reason that they are putting their lives at risk. They are paying money to thugs and thieves. They are in desperate situation. We understand that. There are many millions of people who are economic and political refugees around the world. But getting on a boat and sailing across the ocean, as so many people are doing right now, is not the answer. And there is no doubt, and I make no apology for the fact, that this bill contains provisions to make New Zealand less attractive as a destination for those people. But the exercise barrier certainly identified some administrative challenges in respect of the management of a mass arrival should one occur, and this bill will also include steps to take in order to identify and remedy those, including the ability for a judge to issue a group warrant to house and detain people until their security status, their health issues and the validity of their asylum claim is sought. One issue that has been raised, and certainly with our confidence and supply partners, has been the definition of a mass arrival. This was also touched on, and I want to acknowledge the support and cooperation of Peter Dunn, who has, and the very good grace with which he cooperated with me on the progression of this bill, and also of the Maori Party, who are also supporting the bill at this point. The definition of a mass arrival has been proposed by Mr Dunn to increase from the number of 10 to 30, and the government will support that SOP. It won't support the other SOPs that have been put up, but I do want to acknowledge the SOB in the name of the Right Honourable Winston Peters, and he indeed spoke on this point in the second reading while supporting it, which I certainly acknowledge. And the issue around this was, in fact, we have competing objectives in respect of the appropriate place for detention of irregular mass arrivals, and it seemed on the face of Mr Peters' second reading speech that he wanted to go a little bit harder than the government was. I'm not quite sure that was actually what was reflected in the SOP, but nevertheless it's an appropriate concern to ensure that those people arriving by boat in this way are detained in a place that is appropriate for and commensurate with their risk and their need. And I think that that's what is behind the effort, Mr Chairman.
The Honourable Michael Woodhouse.
I think that's what's behind the Right Honourable Member's SOP, and I want to acknowledge that. But the Immigration Act itself doesn't specify exactly what those places of detention might be, but it does go on to name certain forms of detention, which might be a police station, a prison, premises approved by MB, other residences, domestic residences, and all of that would be in accordance with the risk that's been identified. Now, the government has made a commitment to invest a significant amount of money in the upgrade of the Mangere Refugee Resettlement Centre in South Auckland, and that is likely to be the place where the vast majority of refugees, irregular or not, are going to be located. It is not appropriate and it is not possible for those detained at Mangere simply to come and go. There are severe restrictions on their ability to, on their freedom of movement while their asylum claims are being assessed. However, it is not a prison. Nevertheless, on boats there are going to be three types of occupant. There is going to be those who have paid to be there, the victims of people smuggling. There are going to be the traffickers, the people who are piloting the ships. And then, of course, there are going to be people for whom they are known by other nations as terrorist suspects, and those people need to be weeded out. Where it's appropriate, there will be a higher level of detention. So in acknowledging the New Zealand First concern and the SOP that's been put up, the government will not be supporting that. I have an SOP and it's in response to a very technical error in the omission of 3 words in the 2009 Act when it was passed. Members may recall the case known as the Konsaijan case, a Thai national who was charged with aiding the flow into New Zealand of people for the purposes of working in breach of the terms of their visa. But because of 3 words that were left out of the 2009 Act, it was not possible to prosecute. I have committed to putting those 3 words back. In fact, those who have read the SOP will see that there's a great deal more words than that, and I think it's going to be as watertight as possible, that even if people who have legitimate visas are coming here with the intention of not complying with the terms of those visas, anybody who facilitates that process will be subject to conviction. The last thing I want to just say at this time is in respect of some rather nonsensical speeches that we heard when this committee stage started. We heard references to ghost ships. We heard references from Mr Cunliffe that it was more likely that somebody would come from Mars than Indonesia or Wagistan. And I think, frankly, that is not only wrong, I believe it's deliberately so. And I wonder whether those people just know that they might not be here by the time a ship arrives, so that they don't have to account for the nonsense statements that they have been making. And I can go through a number of publicly known attempts by IMAs who have New Zealand as their destination. They date back 10 years and they are continuing. As we know, in April this year, a rickety 14-metre wooden-hulled vessel with about 60 people arrived at the West Australian port of Geraldton, and the Australian Customs and Border Protection in their report confirmed that the target was New Zealand. The vessel's intended destination was New Zealand. And they knew that because of the master of the vessel testimony and an analysis of data on board which confirmed the vessel was heading for New Zealand. 14 metres, wooden, well-resourced, well-fuelled. It had GPS on board, obviously, or sat-nav, because they had on-board data that confirmed that was the target. And anybody who believes that that could not have occurred forgets that most of our ancestors came here on wooden-hulled sailing ships and waka to say that nobody could cross the Tasman. We have members of our country who have rowed across the Tasman when they're well-resourced and they have the right technology. Anybody who thinks this could not happen is being either deliberately evasive or naive. I think this bill deserves better than that. This is an important bill. It sends a very strong signal to those people who would exploit vulnerable people that New Zealand is not a soft touch, and when they get here, they will be detained in a place commensurate while their status is determined, and they may well be turned around, as 80% of asylum seekers in this country are.
I'll call Dr. David Clark.
Mr. Chair, following that speech, that typically generous